Okay, to close this first day of excellent presentations and discussions, it's my pleasure to introduce the 2016 Harold Buchwald Memorial Lecture on Human Rights. Harold Buchwald was born in Winnipeg in 1928 and educated at the University of Manitoba, receiving his Master of Laws degree in 1957. He was a founding partner of the law firm Buchwald, Asper, Henteloff, now Pitt Blado, and during a highly distinguished legal career, he was appointed Queen's Counsel in 1966, served as president of the Manitoba Bar Association, as president of the Law Society of Manitoba, received the Order of Canada, and received an honorary Doctor of Laws from the University of Manitoba. Mr. Buchwald served in a variety of leadership capacities in numerous organizations in both the Jewish and non-Jewish communities in Winnipeg. Among his many affiliations, he served as president of the Jewish Foundation of Manitoba, chair of the Health Sciences Center, chair of the Ethics Committee of the Winnipeg Regional Hospital Authority, and board member of the Arthur V. Morrow Center for Peace and Justice at the University of Manitoba. Mr. Buchwald was a lifelong supporter of the Hebrew University of Jerusalem, serving as Winnipeg chapter president of the Canadian Friends of Hebrew University, national vice president of the Canadian Friends, and a member of Hebrew University's International Board of Governors, and received an honorary fellowship from the Hebrew University. Sadly, he died in 2008, shortly before the inaugural Harold Buchwald Lecture on Human Rights at the Faculty of Law here. Our deep gratitude goes out to the Buchwald family and to the Canadian Friends of Hebrew University for providing us with this wonderful opportunity. There could, of course, be no more fitting choice for the 2016 Buchwald Memorial Lecture on Human Rights than Professor Françoise Hampson. Françoise is an emeritus professor in the Law School and Human Rights Center of the University of Essex, an internationally renowned scholar of human rights law and the law of armed conflict. She has published widely in these fields and mentored generations of young students and practitioners. She was a member of the steering group and the group of experts for the Red Cross study on customary international humanitarian law. She regularly teaches on the advanced course and at workshops at the International Institute of Humanitarian Law in San Remo. She was a member of the UN Subcommission on the Promotion and Protection of Human Rights from 1998 to 2007. Françoise is an expert on the European Convention on Human Rights and has been the legal representative of applicants before the European Court in many cases arising out of military operations. In recognition of their litigation on behalf of Turks of Kurdish origin, she and her colleague, Professor Kevin Boyle, were given the award Human Rights Lawyer of the Year in 1998. More recently, she and her colleague, Professor Noam Lubel, have submitted third-party interventions to the court in the cases of Hassan versus UK and Georgia versus Russia #2. In 2005, finally, she was awarded an OBE for services to international law and human rights. Tonight's 2016 Harold Buchwald Memorial Lecture in Human Rights is titled The Nature and Scope of the Obligation to Monitor and Investigate Violations under the Law of Armed Conflict. Please welcome Françoise Hampson.
I should like to thank the Harold Buchwald family and the Canadians who supported this lecture for sponsoring the lecture, and above all to thank Yuval and Danny for inviting me to deliver it. I can't help feeling it's a matter of almost a Trade Descriptions Act violation. The one thing I won't be talking about is human rights law. Nor will I be talking about international criminal law, except in both cases to make passing references to them. What I will be talking about is the law of armed conflict. When I proposed this topic, I assumed that Danny was going to say, oh, not investigations again. I feared the reaction was, we've done it to death. But in fact, I've been struck by the number of presentations on the program that in one way or another are looking at the question of accountability in some form. So, and another thing that'll be a bit different. My starting point is not Israel. It may be that it shares the end point with the UK. My starting point is the United Kingdom. If I can get into this. What the problem in the United Kingdom is that there is an awful lot of noise that's being generated about how the post-Iraq and to a lesser extent post-Afghanistan investigations have been handled. That means I'm going to need to explain very briefly what has actually happened before looking up what the noise is about. This is very edited highlights, and even this is bizarre enough. At the time of the operation in Iraq, we had a radically flawed system of investigations, as the European Court of Human Rights found in Al-Asqani. One of the main objections was that a military commander could tell the investigators to stop investigating. So it's as flawed as that. And that has in fact been corrected. But it meant that what happened at the time was not going to be seen as adequate. There was the notorious case of Baha Musa, who had an incredible number of visible injuries when he died in the custody of the regiment is known officially as the Queen's Lancashire Regiment, unofficially as the Queen's Last Resort. And the medic who saw him must have been blind, which I would have thought would be a disqualification because he said he could see no visible sign of injury. The scandal of the Baha Musa case led, in that specific case, to the Gage inquiry. So a hugely costly public inquiry looking at all sorts of aspects of detention. In the meantime, a lot of other allegations were being made before the court. And as a result of the Al-Asqani litigation, it became clear that the European Convention on Human Rights was applicable. So they needed to know what they needed to do in the way of investigations. As a result of the Al-Swedi litigation, as you can see, the courts have played an important role here. It led to the establishment of what's known as IHAT, the Iraq Historic Allegations Team. The function of IHAT is principally, overwhelmingly, to investigate possible criminal liability. There is also a possibility for them to refer any evidence of systematic problems to something else that was created, which was IHAP, but in fact that has been disbanded. There were challenges to the independence of IHAT because of on the basis on which it was composed, and those challenges were successful and led to changes in the composition of the body. If IHAT reaches the conclusion on the basis of the evidence that they think there might be something criminal, that is passed to an independent prosecuting authority who will determine whether or not criminal charges should be brought, that takes the decision about prosecution. In the meantime, something else was created in 2012. Something called the Systemic Issues Working Group in the Ministry of Defence. I'm surprised they're not making more noise about this. If you actually Google that, you would probably get something. But if you just look at MOD systemic violations, I suspect it won't surface. They don't claim to be keeping it a secret, but in effect it's a bit as if it's a well-kept secret. That is designed, as the name suggests, to see whether there's evidence of things needing to be corrected. It is specifically not about criminal liability. What it's about is prevention. Paragraph 1 of its latest report says, the MOD is committed to a continuous process of review and improvement in all matters arising from operational activity, including ensuring that mechanisms are in place to prevent the recurrence of any incidents of wrongdoing. As part of this, it has put in place a robust process for identifying, reviewing, and correcting areas where its doctrine, policy, or training has been insufficient to prevent practices of individual conduct that breach its obligations under domestic and/or international law. These shortcomings of procedure are commonly termed systemic issues. So there is now a mechanism for looking at systemic issues with a view to preventing violations. In the meantime, in Ali Zuka Musa and others versus the Secretary of State for Defense number 2 on the 24th of May 2013, the court had to look at whether the pattern of investigatory activity was sufficient to discharge the responsibility of the UK government. So you'd got IHAT dealing with criminal investigations, then a separate decision with regard to prosecution. You'd got by then the Systemic Issues Working Group. And the court ruled that that combination was not sufficient because the Systemic Issues Working Group was not independent. They were satisfied on the criminal side. The problem was, they said, the obligation of the UK extends to a wide examination of what happened and what can be said to have gone wrong. For example, looking at issues like the planning of an operation, the obligation of the UK was not limited to things being merely criminal. So it had to deliver a wider range of investigation than the criminal side of things, and the Systemic Issues Working Group might, they didn't take a position on this, might have been sufficient, but for the fact that clearly it was both militarily and politically in the hierarchy because it consists of civil servants working for the Ministry of Defence. So the court, the applicant said, right, given that that's not sufficient, what we need is an overarching public inquiry. Well, bearing in mind the scores of millions that the inquiry into Bloody Sunday cost, an overarching inquiry into the entirety of the Iraq and Afghan operations would have gone on for the next 20 years and would have cost even more than the current British deficit. So clearly something else was going to be suggested, and what the court came up with is slightly odd. They said that what was needed was a procedure based on coronial inquest, coroner's courts. They didn't say it had to be the same as coroner's courts, but a procedure based on it. Now, we've had to overhaul our system of coronial inquests because they were seen to be too narrow. Coroner's inquests now don't just look to determine what was the cause of death, but what were the circumstances that brought about the death. But coroner's courts are limited to dead bodies. And you can have, and indeed the cases before the court in this case, didn't all concern dead bodies. Some of them concern tortured bodies or allegedly tortured bodies. And you can have other violations via jail. So I don't know how useful this framework of coroner's inquests will be. That's something that one may need to consider. Now, that's where the UK has got itself into a mess. Not surprisingly, this has resulted in uproar amongst armed forces, ordinary members of armed forces, senior military officers, think tanks, and also the newspapers have got in on the act. They've got a range of objections, some of which I'm sympathetic to, but it's often difficult to disentangle what precise objection any given commentator is making. One objection is the sheer number of times someone may need to give evidence about the same incident. It could be the original investigation and IHAT, and if there's criminal proceedings that, and the coroner's inquest. So they're repeatedly going over old ground. Another objection is the length of time that has passed after which they're required to remember things. So in the case of the Iraq invasion, that means you're going back 13 years. But there are also wider objections, and indeed some of them, it seems to me, challenge whether there should be investigations at all. There is a report produced by what's generally regarded as a right-wing think tank, Policy Exchange, called Fog of Law. The two authors of that, Tugendhat and a former American military lawyer, claim that they're not opposed to the principle of accountability. But if you read that report, it seems to leave no space for legal accountability. I would suggest that they're only leaving space for political accountability, but that's not what they claim, but I think that's what they, in effect, seem to be saying. And when the forces that want to attack what's going on, and in the case of the press, it's not just the tabloid press like the Daily Mail, it includes the Daily Telegraph, also known as the Torygraph. When they're making their objections, they are blaming the Human Rights Act. All this is the fault of the Human Rights Act. Therefore, get rid of the Human Rights Act in total, and if you're not going to do that, make sure that it doesn't apply to military operations, certainly not those overseas. And on that particular point, bearing in mind the cost of all this, people who are in favour of some accountability sometimes are sympathetic to this argument. A further complication has been that, because most of the cases are brought by foreign victims, but there's been a small group of cases brought by British servicemen and the next of kin of British servicemen, challenging the circumstances in which, or the equipment with which they were sent out to fight, which raises a different question, which is the scope of combat immunity. So clearly there's a challenge going on, and as I say, it's being blamed on the Human Rights Act. But I think this means that we need to look at why investigations happen. Why is it not advancing it? Oh, we've got to do it twice. Now I want to look at why militarily some form of investigation is important. The first thing is, if you are to exercise command and control over your forces, you've got to know that they're working within rules, and that if they don't obey the rules, you can have some kind of impact on them. So it's actually an essential tool of command and control. Another argument which applies, that the military are sensitive to, and also politicians take into account, if you are involved in foreign military operations, particularly those where there is arguably a violation of the jus ad bellum, then it does help if you're thought to fight lawfully. It's perceived as giving legitimacy, not necessarily under the jus ad bellum. It gives you legitimacy. It gives you the moral high ground. Well, if you're not investigating anything, you're not going to maintain that legitimacy for very long. Also, in the case of the UK, one reason for criminal investigations is to keep the guys out of the ICC. Because if you don't have effective investigations, as we heard earlier today, then they are vulnerable to proceedings there. So there's a good reason for investigations, but there's a lot of noise being made about it. So clearly, we need to get it right, and to get it right at the time, not 13 years after the event. And at the early stages, where you're not certain whether any violation has occurred, what is necessary is something as light as possible. You don't want serving military personnel to be spending hours doing things with or for lawyers. Ideally, you want them almost not to notice that the monitoring is occurring at an early stage. If something needs a much more thorough investigation, then that will shift. Because if you don't get it right, then I think I do take seriously the military arguments. I think there are problems of morale and retention, and I think there's a real risk that military forces will be too cautious when they're going into operations, and that is dangerous for them and possibly dangerous for civilians that they may be trying to protect. So there's a lot at stake in getting this thing right. I then suggest that when you're looking at, right, what should we do about this? Academic lawyers and practitioners, and possibly others, I hesitate to say that maybe the lawyers working for states might do this, they fall into a very dangerous temptation. You go for what's sexy. You go for what's fashionable. You don't go back to first principles. And if you don't go back to first principles, you make mistakes. I can give examples both from teaching and, I'm ashamed to say, from my own practice of that. It's not specifically on this issue, but it relates to the ease of making mistakes if you don't go back to first principles. A way in which you are guaranteed to get students making a complete mess of a problem question in human rights. You give them a problem question, you've already they've already had your admissibility class, you give them all the facts of a problem at the end of which someone ends up dead, and they all dive into protection of the right to life. You have also, in the facts, either given clear evidence of a failure to exhaust domestic remedies or it's out of time, and they don't notice it. Because it's been sexy, it's all this fancy stuff about when can you open fire. I've seen the same thing in the law of armed conflict. Students make the mistake of failing to ask if it's an armed conflict. Military people in San Remo make the mistake, if you give them a lot of information about foreseeable casualties, they look at proportionality before they've decided if it's a military objective. So what is, and my practice, it's the case of Aksoy. In Aksoy, which involved an unlawfully long period of detention, notwithstanding a derogation in southeast Turkey in the 1990s, Because of Brogan and Brannigan and McBride, I said, this is too long because there were no safeguards. European Court of Human Rights said, never mind the safeguards, it's just too long. Well, I should have argued that. I should have said, one, it's too long, and on top of it, it's too long because of lack of safeguards. What happens here? For 20 years, very understandably, international lawyers all over the place have been crawling around international criminal law. Until the mid-1990s, it was the poor abandoned baby that the ILC couldn't get its teeth into in the late 1940s. Since then, it's been transformed. You've now got a remarkable number of unemployed PhDs with PhDs in international criminal law because that's where it's at. In the process, we've actually forgotten state responsibility. We've forgotten civil, and that's what I mean in this context, i.e. non-criminal responsibility, and that's what I'm going to be concentrating on. So, what is the nature of the law of armed conflict? You know, if you violate the Geneva Conventions, that is not criminal because it binds parties, and you can't jail the state. An easy shortcut, if you want to know if something is civil or criminal, say, where would you go to enforce, to bring a complaint about a violation? If you've got a complaint about a violation of the Geneva Conventions, you go to the ICJ. India did with Pakistan over treatment of PWs. That's where you go to say that another party has breached the Geneva Conventions. You don't go to the ICC. You might send someone to the ICC as part of your own obligation, part of it, to bring criminal proceedings. If you haven't done it yourself or can't, you may send them there. But the ICC and national criminal proceedings are part of the process whereby a state gives effect to its own obligation. But it isn't its own obligation. The reason you needed the Rome Statute, and above all elements of the crime, is you couldn't use the Geneva Conventions as a definition of crimes. There was no indication of mens rea, there was no indication of elements of the crime. You needed something else. So LOAC is the obligations of the state. And in this context, it can also be other parties. And LOAC, or IHL, is civil in character, with all the implications that flow from that. Now, I don't want it to be thought that I'm dissing ICL. It's really important, and it has an important place, but if you're looking at violations of LOAC, it is not the starting point. Because there are plenty of violations of LOAC that do not involve criminal law. Now, it saddens me, and some of you will appreciate, to recognize this fact, but for example, if a state fails to provide prisoners of war with their cigarette ration, personally I think it's a grave breach, but I recognize that the majority will no doubt say it's neither a grave breach nor a war crime, but there is no doubt that it's a violation of GC3. So there's a lot of violations of LOAC IHL which aren't criminal, and the definition is often different. As we'll see later, proportionality is defined differently when you're talking about the criminal offence and when you're talking about the violation of LOAC. Now, it may well be that the party, one of whose state agents has violated LOAC, it may have a legal obligation to bring criminal proceedings. But that doesn't make LOAC criminal. It simply means that as part of its obligation under LOAC, it is required, in the case of grave breaches, and may, in the case of war crimes, bring criminal proceedings against perpetrators. Those, in some cases, will be necessary, but it's not sufficient to discharge the obligations of the party. For example, you may actually, sordid word, you may actually need to compensate, which maybe that's why states aren't looking properly at state responsibility. So going back to basics, and I apologize if this is going to seem like International 101, the focus has to be on the obligation of the party because it's parties that are bound by LOAC. That's going to require an examination of both LOAC and, in one context, general international law about what you have to do when certain things happen in international law, specifically the law of state responsibility. So that's where I'm coming from, and it's why I'm not looking at ICL and I'm not looking at human rights law. The first question, I'll be looking at the prevention of violations and the investigation of violations after they've occurred. I will take no position, I think it's arguable, but I'm not taking any position on whether generally in international law there is an obligation always to prevent any violation of international law. There is clearly such an obligation under the law of armed conflict. And I'll take them in reverse order because I think the second one I'll address is more important. First of all, there's the express words of AP1, Articles 86.2 and 87. That's basically the obligation of a commander to prevent violations that he knows or ought to have known are going to occur. There's an implication of proximity, not necessarily geographic, but it's because he's supposed to have put in place systems and relationships that means he will be alerted to people going off the rails, in which case he needs to positively take action to prevent the violation occurring. Now, I'd call that, if you like, tactical prevention. There's a more important bit, and that's this vexatious phrase, respect and ensure respect. I am not dealing here with the contentious provision in the commentaries on whether there's an obligation to take steps because of what other parties are doing. The state has an obligation itself to respect, which means its armed forces can't themselves violate. But that's not all that's in Common Article 1. The state also has the obligation to ensure respect. That means taking steps to avoid violations or taking steps to ensure that the respect will happen. So that's already the obligation to prevent violations in the form of ensuring respect is already found in the law. So what are the implications of ensuring respect by putting in place systems which will avoid violations? Well, first of all, training. Also, weapons reviews to make sure that the weapons that they're using are not going to give rise to violations. It's also got implications for doctrine. I've added another thing because I think there's some things the military do that aren't necessarily labelled doctrine. When you are deciding, for example, whether to launch an airstrike, you'll have a national, you've been trained in the national way of determining whether you can target something. For example, you will have a national rule that you just automatically take for granted. I don't mean a legal rule, but the national way of deciding what you do with human intelligence. Do you need corroboration, or can you just take one statement? Does it depend on the statements before? That I regard as the national way of doing things. It may not be in a doctrine, but the military, that's how they operate. When they're involved in a certain form of activity, they're going to be doing that. Well, you've got to make sure that that is not going to give rise to violations. And I would argue that the obligation to prevent violations actually means that you've got to monitor things that are occurring. Because if you wait for things to go wrong, you're not going to pick up patterns that may emerge. For example, it could be that 10 different things occur in 10 different places within the period of a month, which each on their own you think is not necessarily a violation. But it could emerge, for example, that a weapon keeps falling short of its target area, but only does it when it's used in wet weather. It may be screwing up its system for measuring distance, for example. Now, in that case, you need to be monitoring how things operate in order to pick up not actual violations, but things that might be violations. And that's exactly what that Systemic Issues Working Group is designed to do. It's not there to find violations, it's there to see, are there patterns, are there things we should be concerned about which we need more information? So, I would argue that as part of the obligation to ensure respect, there's an obligation to monitor, not investigate, monitor, gather information. But this needs to be kept as light as possible. And above all, you don't want to be burdening the armed forces too much. But in fact, the good news is, effectively, in some ways it happens already. People may not be asking themselves the right questions, but the reports are there. After, say, a patrol goes out, when they come back in, the leader of the patrol will compile a report. That then will be looked at by other people in the same, for example, forward operating base, and other people in that area, and possibly at theatre level, because they want to learn lessons. What's the enemy doing now? Is there anything new about it? Is there anything new in the weapons they're using? So they're producing these things, and it's perfectly possible to send these reports that are circulating in theatre back to your home MOD, because that's where this systemic monitoring could happen, and get them to look at it. But you do need them to be looking to see, to be asking the legal question. Not just, what does this tell us about how the enemy is behaving, what does this tell us about the weapon system, but someone needs to be asking the question, is there any basis of legal concern here? Now, there I've assumed that you're looking at things ahead of time, but it's possible that on a particular incident, on a particular occasion, may involve something that you think is a violation. In other words, a report may reach a monitoring body which on the face of it suggests a violation has occurred. That I will look at in the next section when I'm not dealing with prevention of violations, but when I'm looking at investigations. Because an investigation is once it's happened, prevention is before it happens. So the same body may pick up that information. And clearly, it may be that they need more information, in which case they can go back down the line. But the starting point should be the reports that are already compiled. Right, what about investigation? Is there an obligation under the law of armed conflict to investigate, and if so, in what circumstances? There's certainly an obligation to bring criminal proceedings in the case of grave breaches. There's an obligation to suppress, whatever that means, all other violations. Now, it's not clear, and it would make a significant difference, whether that means, whether the implication was, because it's in the section about criminal proceedings, that they're talking about other criminal proceedings, not grave breach criminal proceedings, or whether it's potentially broader, because as a matter of language, suppress means put an end to, and it doesn't necessarily mean it has to be via criminal proceedings. So there's a query as to the scope, and I hope the new ICRC commentaries will look at, is suppress limited to criminal activity, or is it broader than that? And also, whilst you're about it, can you reconfirm, please, ICRC, that suppress applies to all violations, including violations of Common Article 3. There's also express provision in each of the 4 Geneva Conventions for inquiries, but that's subject to the agreement of the parties as to procedure, and effectively has not operated since the end of the First World War. During the First World War, they did have inquiries about where ships were when things happened to them. There's an express provision in AP1 on the provision of compensation if necessary, and AP1 spells out the fact, which didn't need spelling out as part of international law generally. The state or the party is responsible for all acts committed by persons forming part of its armed forces. In other words, if a member of the state's armed forces breaches the Geneva Conventions, whether or not that is a crime, it engages the responsibility of the state. But there's a lack of specificity about investigations in there. Is there anything clearer in the law of state responsibility? Now, this would apply to the law of armed conflict because it would apply across the board. An interesting point about Article 1 of the ILC principles is it states every internationally wrongful act of a state entails the international responsibility of that state. They don't say when you've lost a case. They don't say when a complaint has been made. The responsibility is triggered by the internationally wrongful act, even if nobody knows about it, and even if nobody has complained about it. That's interesting. There is a specific obligation to, in the case of violations, to continue to perform the obligation that you actually, on one occasion, failed to perform. You are required to stop violations and to give assurances and guarantees of non-repetition if necessary, and to provide reparation. Well, certainly, the continuing duty to perform, cessation of violations, and guarantees and assurances of non-repetition, I think those don't necessarily involve legal proceedings. I don't see how reparation can happen other than with legal proceedings. But those are going to require some form of investigation. Because you can't tell if there's been a violation unless you investigate it. If you are required to give assurances and guarantees as to non-repetition, you need to understand what went wrong in order to know what it is you need to correct. So the logic behind the state responsibility rules, and it's not inconsistent with the logic behind the law of armed conflicts, is that the state is required to determine whether or not a violation has occurred. Because if it's occurred, then under LOAC it has to suppress it. If that has a meaning broader than merely criminal proceedings. Under the law of armed conflict, under state responsibility, if that has occurred, it's required to cease the violation. What's more, its investigation has to be of such a type as to enable it to determine not just that something went wrong, but why, so it can take remedial action. And these things are triggered by the alleged violation. So we're clearly going to need to know a bit more about what triggers it. So when do you have to investigate? Now you can't say, well, you wait till there's a violation, because you don't know if there's a violation until you've investigated to see whether. So I would suggest that anyway, you've got these monitoring reports coming in. That's an important paper trail in the event of future litigation. I think we would have saved ourselves all the costs of IAHT if the Ministry of Defence had been able to lay its hands on the right documents. What happened in the Al-Swedi case is that every time the applicants asked for some documents, the Ministry of Defence said, oh, we don't have that. And the court said, well, are you sure? Because it's something you ought to have. No, no, we haven't got it. A few months later, oh, you know that document you were asking for? Well, we've got it. But this other new one, no, we don't have that. Oh, you know that one? And it kept happening. It gave the impression the Ministry of Defence had something to hide. And in fact, all it was incompetence. They couldn't find the documents. If you're going to if you're bearing in mind not merely your obligation to investigate, but how you're going to have some kind of strategy for defending claims, then you need to be able to lay your hands on the paperwork. Because in some cases, it will be blindingly obvious no violation occurred. For example, if you have got a compound in which you've got the enemy's weapons store stored, together with 5 persons who are in the process of making bombs there, and another 20 who are priming other weapons, and no civilians in the place, well, okay, you can record the number of dead and explain in this incident report what they were doing. You don't need any further investigation because the facts speak for themselves. So this is not an onerous thing where you investigate patently lawful killings, but you do need the paperwork. So the early stage is very light. You want a retrievable record. I suggest that the trigger, because there's a question of what the trigger should be, the trigger for something a bit more onerous, I think is probably something like a prima facie case. Oh, it could be even lower than that. I don't know which is higher, possible or prima facie. There, where you've got something that might be a violation, still you're not having anything too elaborate, you need to get more information so you can determine whether it looks as if it really, there's a serious claim that it could be a violation. And at which point, you need to gather as much information as you can for the purposes of civil liability. As you are gathering the information that is enabling you to determine if a violation has occurred, you are going to get a much clearer picture as to whether the possible violation was criminal in character. As soon as you form the view that the violation or possible violation was criminal in character, you're going to need to take that into account because that is going to have to be referred to some other investigation. Now, whether that means that you then stop the civil investigation or whether you can carry on the two in separate tracks, you've got to make sure that the civil investigation doesn't interfere with the integrity of the criminal investigation. But the start of it is the civil process. At the end, if there is a criminal proceeding, that still doesn't get rid of the obligation to investigate the state's liability. And if there's no criminal proceedings, then you need to pick that up. You've got to reach a decision as to whether a violation occurred, if so, what it was and how you can stop it happening again, which requires you to look at why it occurred. So that's how you get I think that's the trigger. and bearing in mind a separate stream for criminal proceedings. What about the framework? And here I want to go back and don't apologise for emphasising we're dealing with civil liability. The criminal law can deal with criminal stuff. This is state responsibility. That will affect the definition of the violation. I heard an eminent specialist in the law of armed conflict, and it was just a casual mistake, it was not he got his law wrong, in San Remo, who said, when talking about proportionality, the test is that the casualties mustn't be clearly excessive. Charles Garraway and I leapt up and down, bounced up and down, and said, that's the criminal law test. The LOAC test is excessive. There's an awful lot of dead civilians between excessive and clearly excessive. And the danger with sliding into the use of criminal law is it actually makes it harder to enforce LOAC because you're applying an inappropriately high standard. Another element that's going to be different is the nature of the evidence that you would need in relevant proceedings will be different. And clearly the standard of proof is different. One would expect in criminal proceedings that you need to establish the case beyond reasonable doubt, whereas it's usually the balance of probabilities in civil proceedings. So it really makes a difference which you're doing, and it's why I don't think the same people can investigate the civil side and the criminal side. It needs to be done by a separate system. But I think there's a problem with two different kinds of investigations that are going to happen. The first is an investigation where you're looking at your own behaviour. You've got a report about something and you say, I'm not comfortable about that, let's look at it. Quite separately, you've got a person making a complaint before some form of court. Now, that investigation, in the context of court proceedings, may need to conform with the normal due process guarantees. What I'm not clear about is whether the internal examination, remember, nobody's challenged you about this. You've got flattened house, some dead civilians, and you're wondering, was it in the circumstances a violation? It's absolutely clear on the facts. For example, what's happened is a building was flattened because the pilot, obeying all his instructions and with no reason to suggest he couldn't rely on the information, targeted a house which, in fact, it turns out, was civilian, and there were a lot of dead civilians in it. And the reason this was not picked up was either the national way of doing things meant you didn't check your human intelligence and it was someone settling scores, or it could be that someone else conceivably could have at least disciplinary liability, but might not have anybody with disciplinary liability. In those circumstances, you've got something saying, we think something's gone wrong here, but nobody has started proceedings. Nobody has said, we want an explanation from you. You're doing it yourself. Now, for it to be any use to you in the event of being challenged, it does need to be as thorough and independent as possible. But I certainly think it can happen within the military. It needs to be outside the operational chain of command, the people gathering the information. It does need to have proper legal input. And remember, you don't need to have criminal lawyers looking at this. You need experts in international law dealing with this. But I don't think it necessarily involves the kind of procedures you'd expect once someone starts making a complaint. Because there, it's partly because it's before a court that you've got the due process before the court. But you need to bear in mind, and the more notorious the case, the more likely this is to happen, that you could be challenged. And if you are challenged, you want to show that your investigation was as thorough as possible, particularly if you've reached the conclusion that there wasn't a violation. Then it's really got to look good. And one of the ways of making it look good is making sure that it's as independent and impartial as possible and as thorough as possible. I would suggest that the test for, how do you know that there's been a satisfactory investigation? There's nothing in LOAC. The test that you'll see here obviously comes from human rights law, but I don't see any reason to believe this would not be an appropriate test for LOAC. What the words mean might be different, but I don't see why. Can LOAC lawyers really object to the idea that the investigation has to be prompt, thorough, effective, independent, and impartial? Are they asking for a biased investigation? Are they asking for one 20 years after the event? It seems to me none of those are particularly problematic. But what is absolutely key here is what is meant by thorough and effective. How much are you expected to do? And that's going to depend on the circumstances. If the problem entirely arose within your own armed forces, then you ought to be able to do something really, really effective. If, however, you need evidence on the ground and you're not in control on the ground, or you need the enemy civilian population or enemy fighters to cooperate and give evidence, less can be expected of you. So, obviously, it's contextual how much can be expected, but quite a useful, not official test would be, if I'm hauled up before a court with the conclusion to this, do I think the court will accept that this investigation was sufficiently thorough, whatever conclusion I come to? That helps to concentrate the mind. Oops, it's done it again. So, what are my conclusions here? I've got two different strands of conclusion. I have the impression that the overwhelming majority of states are failing to give effect to their obligations under LOAC, not under human rights law, under LOAC, with regard to investigations of possible violations and to prevent violations. More than used to in the past, now I think do monitor what's going on with a view to preventing. The problem is, what happens when there is an alleged incident? Some states don't give a toss about any of this, as Aitan showed. But some states are taking that stage seriously with regard to criminal and disciplinary proceedings. A classic example is the report that the Americans issued. It's got all sorts of black all over it where they've deleted bits we can't know. But it's the report on the attack on the MSF hospital in Kunduz. The only questions the US appear to have asked themselves are, one, did anybody commit a crime? They reached a convenient conclusion that no. Two, were disciplinary offences committed? They did bring disciplinary proceedings against people. Are there military lessons we should learn? I have found nothing in there, not a syllable, on is the US as a state responsible for breaching the law of armed conflict? I think there are problems with precautions in attack. I'd like to see how they would wriggle out of that one in Kunduz. And it's not there. And it needs to be there. It doesn't need to be in the same report. It could be a separate process. But that is what's not being looked at. Those obligations, the obligation to investigate violations, is part of general international law and part of LOAC. It isn't the fault of human rights law. Human rights law happens to be really good at dealing with investigations, but it's not the source of the obligation. Where human rights law is giving certain states, notably the UK, a challenge, is it's a vehicle through which claims are being brought against a state which couldn't otherwise be brought. Historically, we had a doctrine called the active state doctrine, which is a bit like the American political question doctrine. Foreigners couldn't bring proceedings concerning the acts of British armed forces overseas before the domestic courts. It appears to be the case that everyone's acting as though that's been abolished. I'm not quite sure why, but the Human Rights Act appears to trump that. So what's happening with the Human Rights Act is it's enabling people to bring claims they wouldn't otherwise have been able to bring. It tells you nothing about the law that's being applied. It's perfectly possible that a human rights body might say there'll only be a violation of human rights law if there's a violation of the law of armed conflict in a particular case. That's in effect the oversimplifying what happened in Hassan in the European Court of Human Rights. So human rights law is creating a vehicle, but it's not the source of it is a source of the obligation, but it's not the only source. If you got rid of the Human Rights Act, or if you kept the ability to make complaints but you change the substantive law, if you said whenever they're dealing with a case involving British servicemen in military operations they must use LOAC, I'd say, whoopee, yeah, okay, I'll carry on bringing cases. So there's been a misdiagnosis of the problem, but that's partly because I'm not aware of any state that actually systematically looks to see, when it's had its criminal and disciplinary investigations, whether or not there's been a violation of the obligations of the state. I do think when you look at how you investigate, I think the ECHR got it wrong in Jalund, but it's not a structural problem there. But the flip side of these conclusions, I think there's a huge job here first for the military lawyers, but also for senior military officers. Because there is no doubt that in the UK there is a crisis about all these investigations within the military. The explaining of why investigations matter is a command function. It's the job of commanding officers to explain to persons under their command why it matters. That's easier to do if they actually believe it matters. And that would be easier to do if you weren't getting innumerable investigations a long time after the event. Now, if we can correct that, if we've got a system that means you get it right at the time, a commander will be able to say, on condition that you complied with your training, on condition that you complied with the ROE and the doctrine, assuming you've updated your doctrine, then any investigation will not involve your criminal liability. It will involve the civil liability of the state. So for God's sake, stop panicking. Because they all act as if they're all going to go to jail, whatever the investigation is. There's a need to make it clear when there's going to be a criminal investigation and what that means, and that means their own wrongdoing. Well, they ought to know about that. And when an investigation does not implicate that. Equally, they need to make it clear how much it matters to the military. They need to make it clear that it will be at least a disciplinary and preferably a criminal violation domestically if they fail to cooperate with an investigation, for example, withholding evidence. But at the same time, it's got to be pointed out to them that it's in their interests that the better the investigation system, the more it's going to protect them down the road. So I think it is possible to come up with a proper system, one that actually addresses all the concerns that are being articulated, but that will only happen when states start looking at, alongside, not instead of, alongside the criminal and disciplinary offences, looking at state responsibility for violations of LOAC. And they could start with doing that in the MSF hospital in Kunduz. Thank you very much.
Thank you. So we have some time for questions. Bruno? Give one microphone to Yuval and then to Bruno up there.
Thank you very much, Francois. Just it's more two comments. The first on your question whether the ICSC commentary addresses the meaning of the word suppress for violations other than grave breaches. It does, paragraph 2896. Where there's a whole range of measures like judicial, disciplinary, administrative, other injunctions that may be issued in order to stop or to prevent the violation from reoccurring, with the final caveat that what will be the appropriate level of dealing with the violation in a non-criminal way will all depend on the gravity of the breach, other than the grave breach being committed. Second, on the issue of civil liability for state violation of IHL. In a previous life, I used to do quite some litigation, both for government and plaintiff side, on exactly those issues for alleged violations of IHL. Most of the time, you don't actually get to a substantive discussion, because of the fact that in many cases, you don't get to the actual IHL discussion of was there a violation of, say, proportionality, because of the fact that in many jurisdictions, states will simply either consider that the treaty doesn't have direct effect, or even if it does direct effect, will say the Geneva Conventions were never intended to confer direct right to individuals, whether it's physical persons or companies, and therefore we basically denied the right to you, individual plaintiff, to even raise the conventions or the protocol as a source of a right. And the other very troublesome factor where the law is entirely unsettled when domestic judges are asked to look at these issues, at the end of the day, they'll approach it from the angle of tort law. Domestic tort law, as they would do for any type of accident that would have happened. I clearly said there's an issue of conflict of laws that would need to be settled in order to clearly indicate what is going to be your final yardstick to determine liability.
I agree about the historic problem, the traditional problem of getting states at the domestic level to deal with LOAC. First of all, there's no doubt that the ICJ could deal with these things. Also, there are circumstances in which the issue can arise. It depends. A state doesn't have the obligation, see the Japanese comfort women litigation, a state doesn't have the obligation to make available its domestic courts, but it may choose to. There's a weird and wonderful case in the English High Court going back to the First World War, Porter and Freudenberg, thank you Ian Brownlee for putting it in his book, where the Hague regulations were applied directly without implementing legislation. I don't understand how they got there. But there may be, there's a range of ways. One, the state may have made it possible. Another possibility is if you've got a domestic system that is trying to give effect to international human rights obligations, and the human rights obligations take account of the law of armed conflict, then you're going to get states needing to look at that. So it can arise there. And you've also got the issue, this will be a tort claim usually, where soldiers of state A are bringing complaints against their own Minister of Defence. And there again, they may need to look at some issues in LOAC. So routinely, I completely agree. But I think the concerns about impunity are probably going to mean that there will be an increasing number of states, sometimes without quite noticing what they're doing, ending up providing their courts with a means of actually looking at IHL. The courts aren't going to want to, but they may have no choice.
I was only commenting about the hypothesis of an individual plaintiff, because the other difficulty is that if you try to sue in front of the domestic court of a state other than the home country, you're going to get the sovereign immunity claim immediately on the table. And so there's been and it's very challenging in cases of coalition warfare, where you basically try to attribute the tort liability to you, and there have been cases of companies with regard to the Serbia-Kosovo conflict heroically trying to bump all member states that were involved of the coalition with extremely mixed results throughout the various courts.
I was one of the applicants' legal representatives in Bankovic when we sued Belgium and 16 other NATO members all in one go. So, been there, done that. But remember that increasingly internationally, if you want to protect sovereign immunity from the courts of foreign states, you're going to have to make available your own courts, because it's not supposed to be a cloak for impunity. And so I think that's going to put pressure on defences like the active state doctrine.
Yeah, I want to join Bruno perhaps well, thank you first. It was an excellent talk. I want to express some skepticism as to how enforceable would be the civil rights or the civil obligations that are being generated on that plane. Perhaps the only place which is effective is the European Court of Human Rights, and this is exactly why the Prime Minister wants to basically take some steps to reduce the exposure of British troops to these proceedings. I also wanted to, on the suppress part, I did glance at the commentary, and Bruno is right. I mean, this is the approach, although the text, of course, is not so clear, and I think the French version is even more open-ended. But I think he's right, and I think the term suppression has, especially in that historical period, had a very specific criminal context, and therefore I would perhaps express some doubts about whether states may decide whether to invoke criminal or disciplinary procedures. I think that in some cases they would have to do that. And you actually gave a couple of examples, perhaps in the proportionality cases, which are not grave breaches, but still raise serious issues. For instance, if they're committed in a non-international armed conflict, then I think there would be, it's not difficult to imagine circumstances under which any response, except the use of criminal proceedings, wouldn't be commensurate with the gravity of the issue at stake. So that was the second point which I wanted to make. And of course, if you do throw international human rights law in the mix, I think it would be very hard to argue that however we interpret suppression, that it would create a lex specialis that would block the ordinary application of human rights law in that context. So if under ordinary circumstances manslaughter should be, for instance, addressed through the criminal law, even if you do not have a grave breach provision, but you do have an obligation to suppress, I simply don't see the argument being made normal. Of course, if there are defenses in criminal law, that's something else. But generally speaking, I think the term may sounded to me a bit weak. And finally, and this is really a question which is which derives from our own experience. You know, we have had a series of reforms in our own investigation laws, which I think improve the situation to some extent. But I think we're still stuck with the issue of high-level accountability. And I'm wondering, what is your take about where does the UK stand in this respect? I mean, when I interviewed, when I was preparing for the Turco committee, and I interviewed one of the senior prosecutors in the UK military in order to pick his brain, so he did explain to me the system, but when we got to the responsibility of, for instance, politicians or senior officials in actually devising a policy which is challenged, the answer is yes, there is a problem there. So there is perhaps, in our case, it has been argued that the solution would be to appoint some commission of inquiry. But the problem in our context is that it would be the government or parliament that would, controlled by the government, that would appoint the commission of inquiry. And I'm wondering whether there is a similar discourse in the UK about ultimately reaching the high levels of accountability.
Taking your point about suppress first, I wasn't suggesting civil proceedings instead of criminal. It's just whether suppress is not only criminal and disciplinary, but could also include civil. So I have no problem at all with saying there may be circumstances in which, even if it's not a grave breach, the only way of suppressing something is criminal proceedings, plus probably other things as well, like revising your doctrine. On the ECHR and the Prime Minister, one of her earliest statements, thank God, bearing in mind we're in a Brexit Britain, was she realised it was politically impossible to withdraw from the European Convention on Human Rights. It does imply she wanted to. But what's also been announced, and I'm not sure that, I take it the Foreign Office lawyers know what they mean, but I'm not sure anybody else does. They've said in future they're going to derogate when they send British forces overseas. Now, I think that the press think that means they're going to say the convention doesn't apply. I'm assuming that they will do it properly, which is to say from which particular rights they're going to derogate. Maybe they will invoke lawful acts of war. So I see that as encouraging. It means that they're getting real. And I think what's important, and I don't know quite what the implications of Hassan will turn out to be, because it's arguable that using the law of armed conflict as the framework for analysis without the need for a derogation in an IAC, they've made it clear it wouldn't apply in IACs, it might not operate in the case of unlawful killings, for the reasons that Marko Milanovic gave in an EJIL blog, that there are other reasons why you might derogate from 5, but the only thing under 15 is lawful acts of war for the killings. So I don't know whether the principle in Hassan will apply across the board. I don't know what's going to happen in NIACs. We'll see in Georgia-Russia number 2, whether they say, well, if you haven't derogated, then we're going to apply these things in the ordinary way. I think the advantage of what happened in Hassan is it requires the European Court to be more disciplined. It seems to me it's impossible to predict what they're going to say in a case involving a NIAC. They get all the facts, they decide they think there's been a violation, and then they fail to address things like whether it was a military objective. They say, oh, well, it was disproportionate. And you can't tell how they're handling cases because they're taking account of the context of conflict. Whereas if they're required to analyse the facts in the light of the law of armed conflict, not to find a violation of the law of armed conflict, but to determine whether it's a violation of human rights law, because that's the only thing they're mandated to do, like the Inter-American Court, then it would be clearer what the reasoning and justification has to be. It will give them an intellectual discipline that would be an advantage, but they're going to find it difficult in NIACs, partly because so much is allegedly customary, so sorting out what the law is part of the problem. So I think in the case of the ECHR, it's certainly, that's a vehicle through which you are getting in a more systematic way than happened with the Inter-Americas, I think, an exploration of these issues, and there are cases in the pipeline, notably Georgia-Russia number 2, where I think interesting things could come out of it, where you may then hit a reaction, I don't know. But I find it objectionable. The reason litigants use the ECHR is because they haven't given us anything under the law of armed conflict. If they gave us a law of armed conflict, means of only seeking redress for violations, not simply because injuries happen, then we'd gladly use it. But because that's not there, human rights bodies are going to be used. They're not best suited, but it does look bizarre if they simply say, oh, well, we don't look at torture when it occurs in armed conflict. I think the dealing with it, but dealing with it in a proper way, makes more sense than not dealing with it. Then on your last point, yes, we have all the same problems about high-level accountability, starting with the Prime Minister and a certain jus ad bellum war. We get newspapers that constantly say, why isn't he in the ICC? Well, it's bloody obvious why he's not before the ICC. I think you'd need occasionally you get things spectacularly more right than we do. We've never had the equivalent of your investigation into the Shabra and Shatila massacre. It's just a pity it took so long that they'd all left the armed forces and were doing other things and founding political parties. But we haven't got anything as good as that. It would be, I mean, in principle, of course they can be subject to court-martials. I don't think that's usually the issue. The issue is the responsibility they bear for coming up with a crack policy. Now, in that case, normally, isn't the appropriate form of responsibility political? I mean, if you've actually broken the law, then yeah, you should be legally responsible. But if you were the one that signed off on a completely lousy detention policy that said interrogators could apply hoods, blindfold people, and fire questions at them for 72 hours non-stop, then I think the obvious solution is 1, political accountability, 2, disciplinary accountability and losing your job, and also some investigation to correct the policy. I think that's what's happening with the interrogators in the UK and quicksands, because they keep lining up to say, oh, we thought we could do these things. Where they got that from, heaven only knows. But I think generally speaking, criminal proceedings would not be the right solution, except if you've got a commander who actually orders a pilot to go and, or orders a member of the armed forces to start disemboweling babies. That's an unlawful order, so he should have criminal proceedings. But if it's a policy thing, I think effective political accountability, including for civil servants and military personnel, plus disciplinary proceedings and losing their job because that performance is so way below anything it could be expected to be, you need to be dismissed, plus formally making it clear how you've overhauled the policy to correct the failings. I think that would be a better solution. But if someone can find a way of getting Tony Blair to the ICC, I'd vote for it. But I know we can't for reasons of jurisdiction. There's a big argument about that historically in Strasbourg, where it looked as if you had to afford just satisfaction and it wasn't clear you had to bring criminal proceedings, so they're saying you're paying for the right to torture. That is certainly not the case. These aren't alternatives. That in those circumstances where you need to bring criminal or disciplinary, and shouldn't be underestimated, disciplinary proceedings, that is there independently of whether there's any issue of reparations. Also, I would like to see a broader, I love the case law of the Inter-American Court on Human Rights on their broad view of reparations. It isn't just money. For example, if someone's missing, then the appropriate remedy should be giving information, as much information as possible as to what happened to that person. And Strasbourg will not address that, it only deals with DOSH. My concern about simply looking at the financial compensation, I wouldn't rule out ex gratia payment on condition that is not a substitute for anything else. If my sister was killed as a result of the acts of British Armed Forces, I don't want an ex gratia payment, I want compensation as of right. And I want the right guy prosecuted. So sort of ex gratia things, if the state does it because it feels like it, as happened with the Americans and Kunduz, fine, that's their lookout, but it hasn't met my complaint at all. And until it's converted to compensation as of right, I'll say, well, you've done that, but I've not registered it because I have got a right to this, and you're saying, oh, we'll do this as a favour. Sorry, no go. So I think you've got to cover, it may be in some cases you're only getting compensation for negligence, in others it may be the actual act. I think there's all sorts of permutations as to what you're getting the compensation for. You see that in the Al-Scani litigation and the Al-Swedi litigation. So yes, it's going to depend on what it's for. For example, I had to do a lot of this. I'd never expected to as a human rights type. With all the litigation in southeast Turkey, we were having to sort out, you know, if someone had been subjected to inhuman treatment in the way in which they were forced out of their house and then their house was set on fire and then they were relocated, I tell you, it was exceedingly difficult trying to get figures for you. It was easy to deal with the non-material claim for the inhuman treatment. Then you had to sort out the value of different bits of cutlery and different forms of this, that and the other. Then you had to sort out the rent they'd paid in Diyarbakir and the cost of displacement. And we put in for everything. Any consultation with them, every bit was in there. But that's what you're entitled to if you're responsible for the harm that gives rise to the consequences. I think there is scope for more creative lawyering there. We tried in one case to interest the German government in something that I thought would be really rather nice. The applicant had fled to Germany as a result of what happened to his brother, and he was bringing a complaint about the death of his brother. And we wanted the German government to join the case, asking to be reimbursed for all the money they had spent on this refugee and this resettlement and everything, because that had been made necessary by what Turkey had done to his brother. And we thought this would give a wonderful way forward in refugee law if the states receiving people were able to pursue the states causing them to flee. And if they're sufficiently wealthy to mean you can get the dosh out of it, why not? But we couldn't get the German government to... They lacked imagination. I think that would have been really creative. Maybe now she'd have done it, but it was about a decade ago. So I think there's very complicated issues here, but I don't think that compensation is ever a substitute for criminal and disciplinary proceedings, nor do I think an ex gratia payment is ever adequate when what you're entitled to is reparation as of right.
Thank you for a wonderful ending to our first day. We reconvene tomorrow at 9. Please join me.